Hello, I'm Lisa Clemo. I'm a partner at Churches. I'm head of the family team, chartered legal executive and resolution accredited specialist. I've been practicing for over 25 years now and have been with the firm for approximately 23. Financial disclosure is essentially setting out in a document or in a letter what you have at the time of your separation. Now, this may be included within a form called a Form E, which you can get from the government website. It's a 30-page document setting out your bank accounts, your business interests, your pension, your income. Now, that document would normally attach to it 12 months bank statements, your P60, your last 3 pay slips, the evaluation of your pension, but it also includes details in respect of your future needs. It may well be your future mortgage raising capacity, property particulars for your future housing needs for yourself and possibly the children. So it has its place. It's a great form, but it can be quite difficult for some clients to complete. So if you have any difficulties with it, please come in and we'll help you through it. Financial disclosure can include details in respect of your property interests. So you would have a valuation of your family home, a redemption statement from your mortgage company, but it also includes details in respect of your income. Now, if this is the case that you're self-employed, you would have your tax returns attached. If you have a business, you would attach 2 years worth of business accounts. In relation to your pensions, you would include a valuation, an up-to-date valuation in the last 12 months of your pension. Now, if this is for the purpose of divorce or dissolving civil partnership, you will need to request from your pension company for them to complete a form called a Form P. The Form P lists lots of questions that have answers that we're going to need should you need to negotiate over your pension claims. As far as financial disclosure, it does depend on who you see as far as a lawyer. There are different ways and different routes to do it. The idea is that you exchange disclosure voluntarily. Now, this can be between you as parties, where you hand each other your bank statements, your pension valuations, and then have a discussion to try and negotiate a deal. It may be through correspondence through solicitors, setting out what you have. But most solicitors and legal representatives do recommend you use a Form E to set out clearly your financial position. It can be expensive to go through the Form E process, so there are alternatives. You can complete a statement of information form, which is a summary form setting out what you have. The main purpose of the disclosure, though, is to set out and be honest with each other. This is what we have. Let's try and resolve by agreement what we have when we separate. Yes, you do. The whole purpose is to be fully upfront with each other of what assets you have so you can negotiate a deal, come to an agreement. The plan is always to try and seek an agreement as early as possible to avoid going to court and to avoid the unnecessary costs and stress that can cause. A Form E is approximately 30 pages setting out your income, your assets, your liabilities, to include pensions. This form can be found from the Government UK website, or you can pop into Churches and we're happy to go through the document for you and assist you through that process. Yes, you do. It's really important, even with small pension schemes, that the court is fully aware of what assets you have. If you're seeking legal advice, I would need to know exactly what it is you have by way of pensions so I can advise you on a potential claim should you separate. The court will need to decide whether a pension sharing order should be made or whether those pension claims offset by one party receiving another asset. The more information you provide to any representative for you, advising you, the more detailed advice they can give. You would have a duty to disclose any immediate inheritance prospects, i.e. you've just sadly lost a relative or a friend and you're just about to receive a payment. You would have to disclose what it is you're about to receive. As far as the court dividing inheritance, that's very much dependent on needs. If there is sufficient capital, other assets that can be divided to meet need to include housing, then the inheritance may not be touched. However, if it is the only asset that you have, it may be the case that the court feels it needs to be divided between the parties to provide for a home. It is really important that you fully disclose to each other, voluntarily ideally, what your assets are. If you fail to make that disclosure, you can't really make any progress about reaching a settlement. Even if you reach an agreement that you're having no financial claims against each other, there is the document filed with the court called a statement of information form, which does require you to fully set out your financial position. So even if you have reached an agreement where there are no claims, you're having a clean break, you still need to include disclosure. The family team at Churches are happy to help you should you need advice, whether it be with regards to a prenuptial agreement, a postnuptial agreement, a separation agreement, or even a consent order. These days, most parties are dealing with divorce on their own, but we're happy where you need us. We have a self-help scheme where we can step in and help you at various parts in the proceedings where perhaps you can't afford for us to do everything for you, or you may decide to fully instruct us to help you through the divorce, dissolution, and in respect to your financial claims.